So today is September 24th, 2025, and this is Section 2 of Admiralty Law, and we're going to begin our recorded version of the talk on Module 6, which is marine insurance. The camera doesn't capture the board, but I have that first page of our electronic textbook up on the screen. Last time I talked about it was unrecorded. It was with this section. But we're going to come in from a different angle this time because I want to coordinate some of the stuff we've already talked about with marine insurance, and this may be a better approach. You know, you can get a lot of ways to get to the same place. So first of all, don't even worry about what it says in the textbook, but you can look at the textbook if you want, but which law applies to marine insurance, federal or state? Anybody? It's a trick question.
Both.
Good answer. Exactly. And how it applies and why it applies is a pretty long, complex story. So we're going to cover the tip of the iceberg of that today, and then we're going to revisit it in Module 7. So in the beginning, by which I mean 1789, 1791, 1789, that's when Congress pretty much laid out federal court's jurisdiction with the Judiciary Act of 1789. There was no involvement of the states with marine insurance, as far as I know. It was purely a matter of federal law. Because it's a maritime matter, you're in court on maritime jurisdiction, it's a marine insurance contract, and state law applied to the state type insurance policies. 1789, there wouldn't have been too much auto insurance, I guess. Horse and carriage insurance, life insurance was around. But maritime insurance or marine insurance had to be uniform, or should be uniform. And certainly it was within the federal court's jurisdiction. I'm not so sure that it would have been considered their exclusive jurisdiction as a matter of law, because if somebody was just suing for damages, I guess the state court could hear it. But I think the truth is, very few marine insurance disputes were heard in state courts in those early years. And so the federal courts developed a body of law relating to marine insurance. In the 250 years since 1776 next year, 200 something less from 1789, in all those years, how many times has Congress stepped in to regulate marine insurance? Another trick question. 1, 2, or 3? 0. Congress has never stepped in to regulate marine insurance. In the UK, there's a comprehensive marine insurance statute. Lots of details. The US has never done that. So try to envision what happened during those first 100 years or so. 150, really. The federal courts basically decided all issues relating to marine insurance. Perhaps once in a while a state court would apply maritime law and apply the law that the federal courts had come up with, but for the most part, it was all federal courts, right on up to the Supreme Court. And this body of judge-made law grew and grew and grew, right up until some strange things happened in the 20th century. What happened in the 20th century? Well, the text talks about the McCarran-Ferguson Act of 1945. You can just see the top line on the screen there, second paragraph of Chapter 10. McCarran-Ferguson was basically Congress saying, we have the power to regulate insurance, right there under the Commerce Clause, because it's commerce, but we're not going to. We're going to leave it to the states. By then, several states had already begun regulating insurance, New York being one of them. In 1938, New York enacted probably the country's first insurance statute. Interestingly, they exempted from the main statute marine insurance because that was a matter of federal law that the courts were handling. But by, I guess 1945 would be 8 years later, Congress made a pronouncement. They didn't really enact anything with McCarran-Ferguson. They basically just said, even though we have the power, we're going to leave it to the states. So that's step one. Then, a little later, and I don't remember the exact year, But to get the year, you look at footnote 990. 1955, okay, so it was the 50s. 3 years before I was born, Wilburn Boat created a big mess. What happened in Wilburn Boat? Well, I'm not going to ask anybody to recite the facts and the law. We're going to cut to the chase. Wilburn Boat involved the question as to whether state or federal law applied. And by then, McCarran-Ferguson was in place and state laws had been enacted. I think this was a boat on Lake Texoma, which I think borders 3 states, certainly a navigable waterway, Texas, Oklahoma, and maybe something else. Anyway, the bottom line after all the litigation, all the way up to the Supreme Court, is the Supreme Court set up a 3-part sequence of things that a federal judge should do, or actually any judge, but they had great authority over the federal judiciary, of course, because, you know, direct hierarchy, right? Anyway, the first thing that a federal court should do when confronted with a question of marine insurance law is look to see if there's a federal rule. And by federal rule, I mean a rule of law created by the courts. So for that first 150 years or so, from say 1789 to the 1950s, 160 years maybe, the federal courts had been developing judge-made law relating to marine insurance. Then came McCarran-Ferguson, 1945, so they knew Congress wasn't going to get into the game because Congress expressly delegated it to the states, every regulation of marine insurance. But the federal courts still, for a while, were addressing marine insurance issues as judge-made law questions. Then along comes Wilburn Boat. In the Supreme Court, I don't know, Solomon analogy, they split the baby. They came up with what they thought was a reasonable compromise. They said, well, rule number 1, if a federal court is confronted with a question of marine insurance, the first thing they do is see if there's a federal rule of law that applies. If there is, they apply it. That's obvious enough. Part 2, if there's no such law, they should consider whether they should fashion such a law. Remember, judge-made law is the backbone of admiralty, so federal judges have a great deal of authority. They're not considered activists when they make a rule of maritime law. So marine insurance dispute, they have to fashion a rule. They are free to do it. But judges often don't like to do that. And sometimes they don't think it's appropriate, and sometimes a combination of both. They don't feel like it. They think they're overstepping their bounds, which they're really not. But they go to step 3. Can anybody guess what step 3 is? This is where it gets messy. Look for a particular rule of law under state law, where whatever state law would apply. So, do you think with 50 states, you're going to have the same rules of law apply across the board, all 50 states? No. A dispute that applies New York law might come out differently than a dispute that applies California law. So right there you can see where the problem is with Wilburn Boat. If there's a federal rule of law in the dispute, like ubere me fide, I'll write that one down, and I'll drop my mouse. It's Latin, and that was actually the rule, one of the things at issue in Wilburn Boat. If there's a federal rule, the court should apply it. But what happened is that, I think in Wilburn Boat, I forget the details, but I think they had to look to state law on some issue in the case. In any event, by 1955, by 1955, when Wilburn Boat was decided, I think you're already starting to see the phenomenon where federal rules are not being generated as quickly. But Wilburn Boat radically changed that and made it even slower. What happened is that the federal courts, after Wilburn Boat, pretty much stopped fashioning new rules related to marine insurance. They skipped which step of those 3 under Wilburn Boat? See if there's a federal law. Well, they did that. And if there's not, and if you don't want to fashion one, you apply state law, whatever state law is relevant. What's the middle step? Just what I said. What they fail to do a lot of times, which is to fashion a new federal rule. So after Wilbur and Boat, there's a phrase, that one's worth writing down too, without dropping the mouse and maybe without getting up. Arrested jurisprudence. Arrested, that's supposed to be a U. Arrested jurisprudence. Anybody want to take a guess what that means? Arrested, not like handcuffs. Arrested like stop growing, like arrested development. Jurisprudence is the development of the law. After Wilbur and Boat, federal judges typically began to go straight from step 1 to step 3. If there's a federal rule in the case books, they apply it. If that issue never came up and there's no such rule, they tend to go straight to state law, which means they're not creating new federal maritime law anymore. And so it's like a kid that grows up to, 4'9", and at age 10 stops growing. And that's what marine insurance law is like in the United States. Arrested jurisprudence. The federal courts stopped developing new principles of maritime law for the most part. Every once in a while, you can convince them that it really should be applied or that it really should be done, but that's rare. So now where are we? Well, there's a whole big difference of opinion among maritime legal scholars. Some say, well, 99% of the time the state rules of law are pretty much similar to what federal courts would do. It pretty much works. And 99% of the time, well, a 1% failure is acceptable in 99% of the disputes, but what about that 1%? Total injustice. You're supposed to have uniformity in maritime law, and you don't. And I can, maybe in the next module 7, we will get to a case I had and a somewhat complex thing. I have a paper about it, about how that came up. And the federal court in that case did not fashion a new rule. I haven't checked to see if they've done in the 10 years since, but probably not. So you have a situation now, because of Wilbur and Boat, that basically keeps the development of marine insurance law in the United States by the courts, by the federal courts, in a state of arrested development. And this does cause a lack of uniformity, maybe not in the majority of cases. I don't know if it's 99% or 1% or 2/3, 1/3, but the bottom line is it is a really serious problem. That's my opinion. Others, this is where there's that difference of opinion among maritime legal scholars. Others say, it's fine, it works well enough, it's close enough for government work, right? But conceptually there's a problem. It arose because of McCarran-Ferguson. Congress got out of the business of regulating insurance at all. They probably should rethink that and regulate marine insurance like England has done, but they haven't, and they probably won't. And the courts have pretty much stopped fashioning new rules of federal law. You have the arrested jurisprudence of marine insurance law due to Wilbur and Boat, and due to the failure of the federal courts to take that second step and be receptive to the idea of fashioning a new rule of law. How many people find this, and feel free to raise your hands because we're going to revisit it, how many people find this whole conceptual thing somewhat murky and confusing? So everybody's got it. Okay. So what we're going to do now is shift gears and put that aside. That was just an introduction to the way it works or fails to work. And now we're going to talk about the nuts and bolts, the stuff that I talked about last time with this group that related to marine insurance. So I will just randomly ask for a volunteer. I don't have my random call-on stuff in place yet. That will happen later in the semester. but perhaps a volunteer will tell me what are the 3 or 4 kinds of marine insurance. Hearing no volunteers, everybody say very still. First person who moves will be called on. You moved.
Me?
Hmm? My peripheral vision is good.
Hull?
Hmm?
Hull insurance?
Hull,
Freight? No.
close, cargo. Give you
I don't know the other one.
P&I, protection and indemnity.
Okay.
There's a handout about that,
Yeah.
which I might put on the screen in a minute or two. The electronic text, I'm not going to bother scrolling down the page because that's problematic. I need an assistant here. Like Pache, Sejak, and Vanna White, you know. Does anybody watch Wheel of Fortune anymore? I never really watched it much. I was a Jeopardy guy, but I don't do either one now. The bottom line is that there's a 4th one, if you want to conceptualize it that way. And does anybody remember what that is from the text, or are they quick? Yes.
Pollution.
Pollution insurance, right. Now that evolved because, you know, back in, I don't know, 1791, say, you didn't have big tankers carrying a lot of oil. Rockefeller hadn't even been born. Great-grandfather probably hadn't even been born. And petroleum products were not, you know, a big thing in 1791. But fast forward, you know, 100 years or so, and now you've got big tankers carrying huge amounts of crude or other petroleum products, and they run aground like what happened in '89 in Prince William Sound with the Exxon Valdez. And you know, Exxon actually didn't need insurance because they were the deepest pocket you can imagine, so they paid billions. You know, that was maybe not chump change, but really something they could afford. But smaller operations really have to worry about that because you can bankrupt the company with one pollution incident, one grounding. And the P&I clubs, which we're going to get to in a minute, they have upper limits. You know, they might cover a $50 million claim, but they're not going to cover a $50 billion claim. So pollution insurance really is what they call, it's largely composed of what is known as reinsurance in the industry, where you pay premiums for a very remote possibility of a very extremely expensive casualty. And that's pollution insurance. So if you want to conceptualize that as number 4, that's fine. I break it down into the big 3, the traditional 3, hull, P&I, and cargo. And when we get to the cargo section of this course, we're going to revisit cargo insurance because the way it interrelates to everything is very important. But for now, I'm just going to gloss over hull pretty quickly. The hull is going to slip right through the water and we're going to get to P&I. Hull insurance is like your collision insurance on your car. The hull gets damaged, you get money for repairs. Hull insurance also has a nuance called the running down clause, which covers a portion of liability, but we're not going to really get into that in this course because there is a separate marine insurance here. Some of you are already in it with Pat Crilly, and we don't need to get into the details of hull on that thing. So that's hull. Put hull aside. P&I is a big one. P&I is a little unusual. It's not the kind of insurance where you pay premiums and get coverage. It's a little different. It's very important in this industry. It's essential in this industry. It stands for, go ahead, anybody? Right on top of the handout. Maybe we'll go to the handout. So here I say there are 3 types. We just talked about them. Pollution will be the 4th if you want to conceptualize it that way. P&I stands for protection and indemnity. We'll cover the indemnity part first. Indemnity is when you cover somebody else's losses. So if you are sued, excuse me, if you're sued and you pay out $500,000, the P&I Club reimburses you the $500,000. They indemnify you. Protection in P&I covers a lot more than that. But before we talk about protection, one little nuance of P&I is that the indemnification part, every P&I club has rules. And every P&I club's rules says the same thing about this idea of pay to be paid. Pay to be paid. You get indemnified, but you got to come up with money first. At least that's the general rule. Pay to be paid. So the idea here is that you better be solvent. If you got that $500,000 claim against you, you do have to pay the claimant, the plaintiff who's won the verdict, or whatever settlement could be, but you have to pay first, and then the P&I club reimburses you. It's a traditional rule. It's been around for a long time. Not sure what the idea was. I guess it was encouraging ship owners to be solvent and have money of their own. It also gets P&I club off the hook a little bit. I'm sorry if this is too low for people. It'll show up on the video. I measured the things. Head, no, it won't be in the way. This is where my head's supposed to end if I sit up straight. I was taught in grammar school. So the pay to be paid principle is a solid rule that's sometimes liquefied. P&I clubs, sometimes as a courtesy, and I got a P&I club to do that to the tune of about $500,000, will kind of sidestep it if they want to work with the member, meaning the insured, if you want to call them the insured. The insured or the member writes a check and then, just send a PDF of the check to the P&I club, and they wire money to the account, and then the money goes out. So they're paid to be, the check is written first, but the money to cover it isn't in the account. But anyway, there's another situation where the P&I club has to waive the pay to be paid principle, but we're going to cover that, unless we have a lot of time today. We're going to cover that in the next module. Anyway, the pay to be paid principle is an important one in P&I because it can kind of cripple you if you're a ship owner who has no money and your P&I club isn't going to work with you, and you've got this $500,000 judgment against you, and they'll indemnify you, but you got to get the money. Then you're going to have to borrow money. I can imagine loan sharks getting involved. But bottom line is that's one of the important principles of P&I. But even more important is how it works. Like I said, they're not commercial underwriters. You don't pay a premium and get coverage. It's a complex system of bookkeeping that involves what are known as calls. The members, and each vessel is a member, and each ship owner is, I guess, considered a member, but it's vessel by vessel. They pay in a certain amount of money every year, but they're subject to back calls before the accounting is closed. So you don't know what your premiums are going to be. They're not premiums. It's very fluid. Why is that? Well, because the P&I club, all the P&I club is really is a big repository for lots of money. So all this calls money goes in, and the P&I club is sitting on maybe $1 billion, and then they're paying out claims. So you pay calls, but you don't know in any given year whether you're going to have paid up. In 2025, you might pay $100,000 in calls, and then the P&I club works their books, and in 2026, you owe them another $40,000. It's a workable system. It sounds a little funny, but remember, P&I clubs are mutual assurance associations. They are not insurance companies. In fact, they're all not-for-profits. They don't actually make any money. They just sit on money and pay it out when the time comes and collect it in the form of calls. With every P&I club, there is a profit-making management arm. There is another company that is bonded to that P&I club. I made the analogy of a lichen, which consists of a fungus bonded to an algae. They're like, joined at the hip, or whatever metaphor you want to use. And for, I could give you names of them, but it doesn't really matter. The bottom line is that it's a one-to-one correspondence. The management arm is connected only to that P&I club, and often is a different management arm in a different country. So, you won't have the same title of the company when you're making a claim over in England as you would in the United States. These are international entities, these P&I clubs. Some of them are more specific to a given nation. We have one American club, like it shows in this handout. Most of them have their headquarters in the UK or maybe Bermuda, which has a close association with the UK. There's one in Japan. There are two in Norway, School and Guard, and there's one that's commonly known as a Swedish club, all maritime nations. But in every case, there is a management arm that is doing all the legwork and essentially showing a profit at the end of the year. They provide services. What services they provide? Well, that's where the P in P&I comes in. Because you have, these days, everybody who's a claims handler in a P&I club is a lawyer. They don't even hire people who don't have a law degree. They evaluate the claim, they assign counsel, and the P&I club pays for that defense. They do a lot more too. They very proactive in preventing loss. So they have, I mean, you look at the websites of any of these clubs, and you can find them by going online, you'll see all kinds of notices and literature and alerts about things that you should do to have a safer ship and avoid liability, etc. It's in their interest to educate their members on avoiding loss. It's in their interest and in their members' interest, right? All the members, because with the call system, if one gets hit, everybody gets hit. So that's another part of the P, the protection. There's another one that they do, which is essential to maritime trade, and that's something called letters of undertaking, which I talked about with this group at the very end of the lecture where I didn't record it, and it was about the same module. I am not going to get into that letters of undertaking thing today because we're not going to have time. That will be part of our next module discussion. And we'll revisit it again later, when we talk about vessel arrests and stuff like that, because it kicks in when a vessel gets arrested. But the P in P&I is a very important thing. The protection part, which is basically done by that management arm. You have assigning counsel, evaluating claims, literature and alerts to keep the members safer and have fewer incidents that cost money, and the letters of undertaking. Those are like the big four of what the protection component is. The indemnity, like I said, is just paying off the proven losses, the claims that are filed in court and then adjudicated or settled. And then, as I said, with pay to be paid, the member pays the money first, and the P&I club indemnification consists of paying back the member, sometimes with a deductible. I'd say always with a deductible, but not a huge deductible. I think in this case that I settled for over $500,000, it was like $10,000. But again, P&I principle of pay to be paid is in some situations waived. There's ways around it. You write the check first, then they deposit the money, or the letter of undertaking is a big exception to the pay to be paid rule. And when we revisit letter of undertaking, you'll see why that has to be the case. So any questions about P&I? I think I've covered everything on P&I for this module. So I would like to get into cargo and then do a wrap-up that kind of revisits everything, and maybe we'll talk about some of the nuances that I referred to earlier. The third one, and pollution we're going to kind of put aside. I explained what it was, and there's really not much more to review on that. We may talk about it briefly in the context of the Exxon Valdez, but the third one of the three that I have enumerated is cargo insurance. So who buys the cargo insurance? The ship owner? No. The shipper and the consignee. Remember, and we'll revisit this in cargo, you basically have three parties, and two of them are related. You have the shipper, the carrier, and the consignee. The shipper is not the carrier. The news reporters make this mistake all the time. A shipper known as CMA, CGM, a shipper known as Maersk Lines. No, they're the carriers. The shipper is the person who is shipping the cargo. And the consignee is the receiver of the cargo. And sometimes it's a transaction that involves purchase and sale, and sometimes the shipper and the consignee are the same business entity, maybe with a different name in a different country or whatever, but they could be related. They might be shipping goods from their factory in China to their distributor in the US. So that's collectively, the two of them together, we can call the cargo interest. So it's the cargo interests who buy the cargo insurance, or not. The bottom line is that cargo insurance with anything of value is almost essential. And the reason for that we'll see when we get to cargo and COGSA. The carrier is not liable for lots of things when cargo gets damaged. They have many outs. So if you want your cargo to arrive safely or arrive at all, and not be, lose money when it doesn't arrive or does get damaged, you need to buy cargo insurance. Otherwise, it's out of your pocket. So cargo insurance is kind of an essential aspect of maritime trade. There is a whole set of things, of rules that they're called Incoterms, which is not in this course, INCOTERMS. It's actually one word, and the International Chamber of Commerce in Paris promulgates those, and everybody adopts them. And they lay out all the details of the terms of a transaction where who pays for the insurance? Is it the shipper or the consignee? So we don't have to get into that here. Business of shipping courses might cover it, stuff like that. But the bottom line is cargo interests pay for cargo insurance. Sometimes they don't, and then, if there's cargo damage or loss, they could sue the carrier, but if it's one of those things where the carrier is exempt under COGSA or whatever international cargo regime applies, then they don't recover from the carrier and they're out the money for the loss or damage to the cargo. So cargo insurance is an essential, third type, and it's quite different from hull and P&I because the party that buys cargo insurance is not the carrier. The hull insurance is obviously something that the ship owner is going to want to purchase, and P&I is something that the ship owner will avail themselves of. But cargo, they don't have, you're not going to get a carrier to buy cargo insurance. You want cargo insurance, you're shipping cargo or receiving cargo, and whatever the deal is under the Incoterms that you agreed on, either the shipper or the carrier pays for the cargo insurance. Or sometimes, I had one small-time importer who didn't buy any cargo insurance, so the only thing we could do for him was sue the carrier. But cargo insurance is routine, and it covers a lot of the things that COGSA would consider not the carrier's fault. So what happens if the damage to the cargo is the carrier's fault? Cargo insurer pays the insured. So let's say there was $50,000 worth of damage to a shipment of cargo, and it was failure of the carrier to care for the cargo properly. Maybe it was refrigerated cargo, and they let the thing get up to 90 degrees in the container, and you can prove that at trial, and you sue the carrier. Shipper sues the carrier, or consignee cargo interest sue the carrier, and they could recover the money. But if they go with cargo insurance, their first step is just to call their insurance agent and say, we got $50,000 worth of damage to our grapes, and write us a check for $45,000 if $5,000 is deductible, and assuming the cargo insurance carrier is coverage is valid and they pay properly, they will pay the money to the cargo interest, and then what might they do? They're out $45,000, and it's the carrier's fault. What do you think the cargo insurer would want to do to get their money back? They could do something. Anybody? No? Well, suppose you're the insurer and you pay on a claim and it was somebody else's fault. Standing in the shoes of your insured, why can't you say, well, I basically bought this claim for $45,000, and so now I want to sue the carrier? And that happens all the time. And that is something that is essential that you will hear in your marine insurance course, but you might as well hear it here first. And that is called subrogation. Subrogation is what I was just talking about, where the insurance provider then sues the party that's liable. In this case, with cargo, the cargo insurer pays for the damage of the cargo. I said $50,000. Maybe they pay $45 because there was a $5,000 deductible, but now they're standing in the shoes of their insured. They are the subrogee of the insured, and they sue the carrier for the damage to the cargo to get their money back. So you'll see a caption on the case that looks something like this. And I think I covered this on that board a week or so ago. You know, Jim's Insurance Company as subrogee of, and that's the typical abbreviation, ASO. Joe's Products, which was the cargo interest, versus, and then you have all the defendants, it might be the vessel in rem and the name of the carrier in personam, but that's your typical caption for a subrogation claim. The principle of subrogation is extremely important in this industry because imagine what it would be like if cargo insurers could not do that. They'd be paying out all these claims and the carriers would be getting off scot-free because there was no device to allow them to recover that money back, even if the carrier was liable. Any decent cargo insurer will evaluate whether it's a viable claim because under COGSA, you know, certain things leave the carrier scot-free as a matter of law. And we'll cover that when we get to cargo. But many times the carrier would be liable. And in those cases, it's typical to see the insurance company sue as subrogee of the insured to go after the carrier for the damages. Everybody understand that? Really important concept in insurance in general, and in marine insurance, particularly in the area of cargo insurance, because that's where you see it come up. You know, without it, like I said, there would be a bit of a mess. What would happen? You know, carriers would be probably less careful because in many cases insurance would cover it, so they don't have to worry about you know, being sued for the loss. The insurance companies would just have to eat the loss. What would that happen to cargo insurance rates? Obviously, it would drive them up because cargo insurers then would be paying all these claims with no hope of recovering any money on the claims that were paid. And then you would have more and more cargo interests avoiding buying cargo insurance at all because it was so expensive. And then I guess you'd have kind of a pendulum swing. Maybe it would reach equilibrium, right? Because then there'd be a lot of uninsured shipments and cargo insurers would directly sue the carrier. But it makes a lot more sense to have the system as we have it. Most principles that we have in maritime commerce and law are sensible. The only exception we'll get to later in the course, it actually exists for longer than marine insurance. It's called general average. And that one might be something that doesn't make sense anymore. But it's around because it's been around a long time and it isn't going away. But we'll get to that later. So questions about all of this are now sought. Who has any questions? Nobody. Okay. The fourth area that we said we weren't going to cover too much is just worth revisiting because it really relies heavily on this concept of reinsurance. Insurance carriers and P&I clubs tend to have upper limits of what they can cover. You can't get a policy that's going to go up to $5 billion very easily, you know, without paying ridiculous premiums. And P&I clubs don't even want to get involved in that because they're sitting on a pool of money, but it has to be a reasonably sized pool of money for claims that are within their ability to handle. So pollution insurance evolved because of these astronomically high claims that many carriers could not possibly pay. And public policy, I mean, you can't have all this damage done and nobody's going to pay for it. You know, Prince William Sound with the Exxon Valdez was, you know, a classic example. But I imagine pollution insurance was around before that. That was 1989. Conveniently 200 years after the 1789 Judiciary Act. I don't know if there's any mystical connection there, but bottom line is that the pollution insurance had to evolve given the circumstances. Pollution damage could be astronomical. I mean, the Exxon Valdez wasn't the first one. There was the Prestige off the coast of Spain earlier than that. You know, there's a long history of massive spills. So and there are other sources of marine pollution besides petroleum products too. I mean, it could be a tanker carrying toxic material, toxic stuff that's not a petroleum product, maybe hydrofluoric acid or something, and the tank is breached, and that stuff goes airborne, and 40,000 people die. What do you think 40,000 deaths are worth in the United States in courts? Millions each times 40,000. So the bottom line is pollution insurance relies on a principle called reinsurance, where the extra coverage, the astronomically high coverage, is handled by very big outfits or very big money outfits that can leverage that kind of money. The exact details in terms of business, I don't know. But the bottom line is that it's a form of reinsurance. Pollution insurance is a form of reinsurance where astronomically high losses can be covered. So the industry adapted to that because law and society required it. You can't have vessels out there that can do that without coverage, and yet we do. How do we have that? What kind of tankers are out there that probably don't have any pollution coverage at all? Anybody ever heard of the dark fleet? Dark fleet carrying Russian oil primarily, registering these vessels in countries that don't even usually have registry. I think one was from Cameroon, and it grounded off of Singapore. Fortunately, there was no spill. That was a couple of years ago. But there's a dark fleet out there that is carrying petroleum products, probably on older ships that don't even get Classification Society certification, and certainly don't have the kind of coverage that you would need to cover the kind of damage they can do. So we're living in perilous times. The way to resolve that is a question of international law, and I don't see any solution on the horizon. By the way, the High Seas Treaty, the Treaty on Biological Diversity Beyond National Jurisdiction, just less than a month ago got the 60th ratification, which means that goes into force in January. That probably won't do anything very fast about the dark fleet, but it is a very important development in international law that all of you should be aware of. You can, if you're interested in it, you can look at a website called High Seas Alliance, just highseasalliance.com. They try to put out public information about it. Guess which big maritime nation has not ratified the High Seas Treaty? You're sitting in it. It takes 2/3 of the Senate to ratify an international treaty. And these days, getting 2/3 of the Senate to agree on anything, especially anything as multifaceted as that treaty, is like, a pipe dream. It's not going to happen anytime soon. But anyway, the pollution insurance is at least covering some of these potential terrible disasters. The one everybody's most familiar with, aside from the BP thing down in the Gulf, which was not a ship, is the Exxon Valdez. I was aware of it when it happened, and it was kind of interesting. I won't tell all the stories on video, but I have a lot of inside information about that thing. Anyway, a little quick one, which is video worthy. What do you think they called all those fishermen and other people up in Alaska who made lots of money? Exxon paid them off. Exxon didn't need reinsurance. Exxon didn't need pollution insurance. Exxon is, big oil. They called them spillionaires because after the spill, they made a lot of money. Make a claim, I can't catch fish anymore because of this pollution, and Exxon settled with them, and there were thousands of them. So, billions of dollars went to the spillionaires. Anyway, that's pollution. So again, the 3 or 4 types are hull, P&I, cargo, and then if you want to consider it a 4th type, pollution. Conceptually, it's not a different type, it's just a liability coverage that goes beyond P&I. So it's not P&I, maybe the first layer is covered by P&I, and then when you're getting into the billions, it's through reinsurance, and that's pollution insurance. There conceivably could be other multi-billion-dollar losses that are not related to pollution. I can't think of what offhand. Well, a big explosion, I guess, a vessel at a terminal, an LNG carrier maybe, nobody wants them in their backyard. It's a NIMBY situation. LNG is great, but not here, Everybody knows what LNG is? Liquefied natural gas? Yeah. That's, you know, I guess you could frame it as pollution. I don't know. There are coverage clauses in all policies, and you know, you have to read the coverage clauses to see whether it's going to be covered or not. So, would an explosion be covered under pollution insurance? If people died from the blast and not the pollution, and you know, CH4 is methane, the primary component of natural gas, it isn't a big polluter. Methane burns kind of clean. Methane that leaks and doesn't explode is actually pollution because that's toxic. That's a really toxic greenhouse gas. Try breathing methane. You know, stick your head in your oven without lighting it sometime, see what happens. But CH4, we'll do a little chemistry real quick. It's worth the aside. You should know this these days, right? Because clean fuel is kind of what we're hoping for. And fossil fuels all have three elements in them: CHO, carbon, hydrogen, and oxygen, except methane doesn't have any oxygen, and it has a lot of CH4, a lot of hydrogen, right? The best fuel would be hydrogen, right, plus 2O2, plus 1O2. Am I right? No, 2H2, there we go, equals 2H2O. Right? So what's the exhaust when you burn hydrogen? Water. You get water vapor. Very clean. We can tolerate water vapor in the atmosphere. Methane, you're burning both of these things. You're oxidizing carbon, you're oxidizing the hydrogen, and so you get, let's see if that balances, well, how many O2 do we have to add? We have to add, I don't know, balance. I'm not going to bother balancing chemistry equations for this class. But the bottom line is that when you burn methane, which is the component of natural gas, the main component, you really don't have any significant pollution. CO2, yeah, it's a greenhouse gas, but I don't think pollution insurance is going to cover, you know, large discharges of CO2 because they'll be absorbed by the atmosphere. You know, the CO2 levels in the Earth's atmosphere will go up a tiny bit from that explosion. But if you had an LNG tanker and all the cargo somehow exploded all at once, which would be hard to do because it wouldn't get enough oxygen, but let's say somehow, you know, an oxygen source, you know, compressed oxygen collided with, you know, in the harbor with an LNG carrier, and you had this amazing, it would be like almost a small nuclear bomb, and then people died from the blast. Would that be pollution insurance? I don't know. It's kind of a sci-fi scenario because I'm not sure what ship would be carrying large amounts of oxygen or how this oxygen would get there. You're oxidizing the hydrogen, and so you get, let's see if that balances, well, how many O2 do we have to add? We have to add, I don't know, balance. I'm not going to bother balancing chemistry equations for this class. But the bottom line is that when you burn methane, which is the component of natural gas, the main component, you really don't have any significant pollution. CO2, yeah, it's a greenhouse gas, but I don't think pollution insurance is going to cover, you know, large discharges of CO2 because they'll be absorbed by the atmosphere. You know, the CO2 levels in the Earth's atmosphere will go up a tiny bit from that explosion. But if you had an LNG tanker and all the cargo somehow exploded all at once, which would be hard to do because it wouldn't get enough oxygen, but let's say somehow, you know, an oxygen source, you know, compressed oxygen collided with, you know, in the harbor with an LNG carrier, and you had this amazing, it would be like almost a small nuclear bomb, and then people died from the blast. Would that be pollution insurance? I don't know. It's kind of a sci-fi scenario because I'm not sure what ship would be carrying large amounts of oxygen or how this oxygen would get there.